Hi, good afternoon, everyone, and thank you for joining today's webinar, The Future of Voting Rights in America, a Landmark Law Under Assault. I'm Vanna Cure, Director of Advocacy and Engagement here at Independent Sector, and I will be moderating today's discussion. If you are new to Independent Sector, welcome. We host a monthly policy series as a benefit for our members, where we share the latest policy developments with you all and their implications for the charitable sector. At the end of today's webinar, my colleague Ben Kershaw will join us for those policy developments, so be sure to stick around for that. Before we begin, I'd like to go over a few housekeeping items for you all. Throughout today's webinar, please share your questions for panelists in the Q&A box. We like for these for these webinars to feel interactive. So as questions arise, please drop them in the Q&A box and our panelists will answer them towards the end of our discussion. Also note that ASL interpretation is available for today's webinar. Simply click the interpretation button on the Zoom toolbar to access it. And lastly, note that this webinar is being recorded and will be shared out with you all in the next 2 to 3 days. So as you all know, the Voting Rights of 1965 has long served as a cornerstone of protections against racial discrimination in voting by helping to ensure communities can challenge voting maps that dilute their political power. In recent years, we've seen the Supreme Court narrow key parts of this law, and now Louisiana versus Callais will test whether Section 2, which our panelists will dive into momentarily, will remain fully enforceable. Now, how does this relate to nonprofits? For nonprofits engaged in civic participation and community education, the outcome could directly affect how you support fair representation and protect voting access. Changes to these protections could shape the legal landscape in which nonprofit civic engagement operates by influencing both the strategies available to organizations and the strength of the community's voices they seek to elevate. I'd like to introduce our panelists for today's webinar. Joining me today is Sejal Javari, Senior Legal Counsel for Litigation at the Campaign Legal Center, Abba Khanna, Partner for Ilias Law Group, and Brian Miller, Executive Director for Nonprofit Vote. So with that, let's dive into today's discussion. We've got a lot to discuss with our panelists. We know a lot has been happening on this topic. And so Sejal, I'll start with you. Could you start by giving us a bit of a history? What was the harm that Section 2 of the VRA designed to address? What does Section 2 actually say, and how does it operate in practice? So break it all down for us.
Sure, I'd be happy to, and thank you so much for giving me the opportunity to talk to you all today. I'm actually going to start a little broader than just Section 2. So I want to start with the context of the Voting Rights Act. The Voting Rights Act was passed in 1965, and it is considered the landmark legislation of the civil rights era. And one of the reasons why is because access to political participation is one of the most key components to a democratic country. To access the ballot box allows access to broader civil rights generally. It allows every person in this country to have their voice heard. And the goal of the Voting Rights Act was to make sure that minority populations, especially Black populations in the United States that had been discriminated against through the Jim Crow era, and for generations before that, were able to exercise their political power in across the country. And so that was the purpose of the Voting Rights Act broadly. The Voting Rights Act has a number of different provisions. It's a pretty lengthy statute and a pretty interesting read overall. I will just add a little bit to my background. I do work currently at the Campaign Legal Center, doing work under the Voting Rights Act and other voting statutes, but I also spent a lot of my career at the Department of Justice doing work primarily under the Voting Rights Act in the voting section of the Civil Rights Division. And so that also influences my view a little bit, which is why I'm going to talk about a few other sections of the Voting Rights Act. Section 2 is what we'll talk about, and I will spend the most amount of time on that, but there is a provision called Section 5 of the Voting Rights Act, which we often refer to as pre-clearance. Basically, this was the really novel part of the Voting Rights Act. This was something that really had not been done before in any federal statute. It required for jurisdictions that were covered by this law, and there was a particular formula that largely included places that had been actively discriminatory in the years prior to the passage of the Voting Rights Act. Those jurisdictions, in sort of a very simple way, had to go to either the Department of Justice or a three-judge federal court in order to change any voting laws that could have a negative effect on a minority population. The standard was called non-retrogression. Now, I use the past tense, and this is where this is going to tie into Section 2. Section 5 is incredibly powerful. It prevented a number of laws from going into effect even before they harmed an individual person. But the Supreme Court, in a case called Shelby County v. Holder, essentially found that the formula that was used to impose preclearance was unconstitutional. And that basically did away with preclearance generally, which means now that states are free to pass whatever laws they want, and there can basically only be challenged on the back end once the law has already been passed, and oftentimes once the law takes effect. And, you saw this on the day that the Shelby County decision came out, which was in June of 2013, June or July, I actually don't remember exactly. The Texas and North Carolina instituted laws that previously would not have gotten preclearance and instituted them immediately, like on that day. And so you could see the power of Section 5, and that power is completely gone. So I give that context to talk about Section 2. So Section 2 is an incredibly powerful tool as well. I'll read you the statutory language and I can talk a little bit more about it. No voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on accounts of race, color, or in contravention of the guarantees set forth in other parts of the Voting Rights Act. So when we think of Section 2 of the Voting Rights Act, it actually covers a couple of different types of claims. For today's discussion, I'm going to not talk too much about vote denial, but vote denial claims are statutes that basically limit access or deny access to the ballot box. Some laws that have been challenged under vote denial claims are things like really extensive voter ID laws or other policies that make it very difficult, especially on account of race, to vote. But what we're going to be talking about today is redistricting. And so the type of claim that is at issue there is called vote dilution. And vote dilution is kind of exactly what it sounds like, where the redistricting scheme or the system used to vote, sometimes some jurisdictions still have what's called an at-large voting system, where every person in a county, for example, chooses every seat on the county board instead of having different districts. And the districts allow people who live in those residentially compact areas to get more of a voice rather than having everyone vote for every single position. So this law can be used to challenge those types of at-large systems or any redistricting schemes, which includes the congressional ones, which is the ones that I think we're most familiar with, that we all see in the news, but also used, and especially when I worked at DOJ, we often did these Section 2 cases about smaller jurisdictions that were about county boards of election, boards of education, that have real impact on local communities, because most of those decisions at that level, they're the ones most felt most closely to each community. But of course, our congressional redistricting is incredibly important. And those claims, they're essentially the argument is that the the districts dilute the vote of a minority population. And in order to show those claims, there are a few prerequisites that you have to establish, and those we refer to as the Jingles factors. And they come from a case called Thornburg v. Jingles. I'm just gonna talk about them very briefly. They can get very complicated, but I'll talk about them very briefly. The first is that the affected minority group is sufficiently large to elect a representative of its choice. So that typically means you can draw a district in which you have a little more than 50% of a minority group in it. That the minority group is politically cohesive, that group tends to vote similarly, doesn't have to be uniformly the same, but similarly. And that the majority voters, which are generally the white voters in any of these districts, vote sufficiently as a bloc to usually defeat the minority group's preferred candidates. So we call those the Jingles factors, and they're sort of the three things that have to be established in order to be able to litigate a case under the Voting Rights Act. And then under this vote dilution claim under the Voting Rights Act. And then the courts will also look at a totality of circumstances in evaluating the claims, and that can vary from everything from like a history of discrimination to various other political factors in a place. And I'm not going to spend a lot of time on all of that. So Section 2, these claims are fact intensive. They're difficult often to make, but they can be incredibly powerful. They can change the weight of coalitions that go to Congress. They give, and most importantly, they do as they are intended, which is to give a voice to those minority groups in states all across the United States. So that's sort of a background on Section 2 of the Voting Rights Act. I will stop there. Did I cover all of your questions before?
I think you did, and I want to make sure we understand from a court's perspective, and I appreciate the history. That was a great overview. From a court's perspective, how does a court define racial gerrymandering?
Right. And so that's a great question. And so racial gerrymandering is sort of the other concept that is at play in Callais and some of the recent Supreme Court decisions on voting law. Racial gerrymandering is a concept that it's a constitutional claim that comes out of a case called Shaw v. Reno. And the sort of simplest way to describe it is that claim says race cannot predominate in the drawing of districts. And just to set up, and I know Abba is going to talk about this a lot more, but just to set up the tension a little bit, I think as I was describing Section 2, we talked about these factors where you have to show certain population of minority voters and things like that. And so we often refer to Section 2 and the VRA as a whole as a race conscious statute. It's not ignorant of race. And the racial predominance standard allows for that. And so where the tension comes in is how much race is being relied on in drawing the districts. And that's where the real tension comes to, and where there are real factual and legal distinctions in some of the cases. So I'll leave it there because I know Abba's going to talk more about it.
Got it. No, that was helpful to actually set the stage for the shift in conversation to focus a little bit more on Louisiana versus Calais. We know there's been a lot of press around the issue, and Abba, I'll bring you in for my next question here. There's actually several cases pending before the Supreme Court right now that could have major impacts for redistricting, excuse me. Can you tell us a little bit about those?
Yeah, and thank you for having us here, and thank you for having me here. Thank you, Sejal, for that great introduction on kind of the concepts we're going to be talking about. And happy to speak with you all a little bit more about how these issues are playing out in real time in these cases. The Callais case, which I think everyone knows most about, is really the centerpiece of what's happening at the Supreme Court right now, of pitting depending on how your outlook on it, pitting the Voting Rights Act, which, as Sejal said, is a intentionally race conscious statute that says that there are voting rights abuses, historical and present day, that need to be corrected by paying attention to racial minorities. And then the Equal Protection Clause of the U.S. Constitution, of the 14th Amendment, which, of course, was a post Civil War amendment designed to eradicate the blatant and the blight of slavery and the disenfranchisement that happened there, but has since been interpreted to require less race consciousness and more color blindness or race blindness. So these two issues kind of come to a head in the Callais case. And I'll just start by saying, like, as Vanna mentioned at the top, I'm a partner at Elias Law Group. Elias Law Group is a law firm that is devoted exclusively to, on the litigation side, to progressive and voting rights causes and helping citizens vote. And so my entire practice is dedicated to voting rights litigation and redistricting litigation. So I've been litigating a lot of the cases that have shaped these laws, and including in the Callais case. The beginning of the Callais case is actually in Section 2 of the Voting Rights Act. In 2022, Louisiana redrew its congressional map, as states do after every census, and it has 6 congressional districts. And it drew one of those districts to be what we call a majority minority district, a majority Black district, or a Black opportunity district. What that means is that there was only 1 out of 6 districts in which Black voters had the opportunity to elect their preferred candidate. And the way that district was drawn was basically to string together Black population from Baton Rouge to New Orleans and just kind of gather it all together in one, such that all of the remaining districts were whitewashed. A bunch of litigants came in under Section 2 and said, well, this is a violation of Section 2 of the Voting Rights Act, and we can march through some of these factors that Sejal just mentioned to prove that. And in some ways, it's a very open and shut textbook case. One is we can show that there are other ways to draw this map so that you can have 2 majority Black districts or 2 Black opportunity districts if you simply unpack that Baton Rouge, New Orleans connection and give them separate districts. And we showed the court how this could be done in ways that made a lot of sense with parish lines and all these kind of traditional redistricting factors. Second thing we had to prove was the existence of what we call racially polarized voting. In Louisiana, we proved it was undisputed. Black voters are voting one way, white voters are voting another way, such that when there's not a majority Black district or when there's a majority white district, the white preferred candidates will almost uniformly defeat the Black preferred. And then finally, we proved what we call the totality of circumstances, which is this kind of long list of factors that are, without getting too much into specifics, the real question of all of them is really, to what extent is politics in this jurisdiction racialized, right? Do we have not just a history of voting related racial discrimination, which of course we do in Louisiana and across the South, but do we also have the remnants of that history today? Do we have present day evidence of official discrimination? Do we have socioeconomic disparities that continue to plague the ability for Black voters to access the political process? Do we have candidates who view race as a campaign statement, good or bad, as a reason to vote for or against candidates? To what extent is race really injected in the political process? So Section 2 litigants brought this lawsuit and we won. But we got a federal court to say, no, Louisiana's congressional map is a violation of Section 2 of the Voting Rights Act, and you need to draw an additional district in which Black voters will have the opportunity to elect their candidates of choice. That was not a singular victory. That was a victory that was held on appeal at the Fifth Circuit. And all of these judges, at the end of the day, I think we had some 7 federal judges weigh in on this issue, and all of them basically found, no, the Section 2 legal standard is very clear, and all of those factors have been met. The state of Louisiana's primary defense against Section 2 was that, wait a second, by demanding an additional majority Black district, by demanding additional what they would call race-based district, that butts up against the Equal Protection Clause and the idea that the constitutional, under the 14th Amendment, we're supposed to live in a race-blind society. So the fact that you guys and your experts, when you drew these proposed maps, were paying attention to race is itself a violation of the Constitution. And the federal judges that we argued before said, well, no, actually, that's not the way the law works. Yes, the Constitution exists and the racial predominance standard. And yes, the Voting Rights Act exists. But as long as we have a Voting Rights Act, it's going to require some element of racial consciousness. The Supreme Court has long held that racial consciousness, in and of itself, when it comes to drawing districts, is not an evil or a constitutional evil. And even though the Supreme Court, up until today, has never actually squarely held that compliance with the Voting Rights Act is a compelling enough interest to justify, some kind of race-based redistricting. The Supreme Court has repeatedly assumed that to be the case, that of course, a state that's trying to comply with federal law, Voting Rights Act, can take account of race without running afoul of the Constitution. So Louisiana, after a couple of years of fighting on this, sees that they lost in the district court, sees that they lost in the Fifth Circuit Court of Appeals. And they've also seen a separate case that's gone up to the Supreme Court already out of Alabama that's on very similar ground, another Section 2 case out of Alabama seeking an additional majority Black district there. And Supreme Court actually ruled in the Section 2 plaintiff's favor in that case as well. So they see the writing on the wall. The federal courts have spoken. Section 2 and its legal standard are not going anywhere. So the Louisiana legislature convene and say, you know what, guys, I think we need to redraw this map. Otherwise, the federal court's going to do it for us. So they proceed to redraw the map pursuant to essentially court order. And in so doing, they draw that second majority Black district, not the way that the litigants had proposed, which is kind of along the Delta parishes in Baton Rouge, but instead they do it in this way that kind of stretches across the state in a pretty haphazard and jagged manner. But the reason that they do it that way is actually very blatantly political. They say, well, we didn't want to do that district that the plaintiffs proposed because that would kind of knock out our favored incumbent, Letlow, and keep in our disfavored incumbent, Graves. And we want to knock out Graves and keep in Letlow. So we're going to do this for this kind of political reason. The reasons that legislatures do things all the time and draw maps all the time to keep in and keep out political favored incumbents, things like that. The minute that they enact this map, which in the Section 2 world, in the Voting Rights Act world, is a victory for Voting Rights Act litigants because it shows that, hey, look at that. Louisiana actually stood up, took notice, federal courts told them what to do, and they did it. Almost immediately, they received a lawsuit kind of from the other side, I believe they termed themselves 11 non-African American voters in Louisiana. They then challenged that new map as a violation of the Constitution, as a racial gerrymander in violation of the Equal Protection Clause, saying you paid too much attention to race in drawing that district. You paid too much attention to what the court said about complying with Section 2. You paid too much attention to where racial pockets were. And that itself is a violation of the Constitution. They bring that case in a separate court, and that court actually agrees with them, or at least two out of three judges on that panel do, and that goes up to the Supreme Court. So that is the current. So after actually several rounds of briefing and argument at the Supreme Court, we are now all waiting with bated breath to hear from the Supreme Court about essentially this question: does drawing a district with race in mind, and I wouldn't call it a race-based district, but a district that is conscious of race, in an effort to comply with Section 2 of the Voting Rights Act, does that necessarily violate the Equal Protection Clause? And really, when you kind of put that question into relief, the question is, what continued vitality does Section 2 of the Voting Rights Act have and allow if we are trying to move toward a race-blind or color-blind society? How much does our law allow for the consideration of race as obviously a remedial issue if we are ultimately hoping toward race blindness? And that's the answer we're waiting to hear upon from the court. Really, it could be any day, and certainly before the end of this term.
No, thank you for that, Abba. That was a great just sort of overlay of what's happened with previous cases. I was going to ask, and I think you partially answered it with talking about the lower courts of how we can anticipate the Supreme Court responding to these challenges. I don't want to speculate. And like I said, I think you've said enough about previous cases. So I'm going to move us along to Brian. And if time allows, we may come back to that. I do want to shift gears a bit to talk specifically about the Voting Rights Act and the charitable sector. Brian, I know you all do this work and do it very well. And there are many nonprofits whose mission involves voter rights, so this is a critical issue for them. But what about the charitable sector in general? Why should boards or staffs at nonprofits and philanthropies care about this issue?
Sure. Thank you, Vanna. And I appreciate the question. And obviously, I really also appreciate all the excellent legal background that Sejal and Abba brought to the table, because that deep understanding of the policy is critical to the question here. But I think I'm obviously here with Nonprofit Vote, and our whole role is to help nonprofits leverage their civic muscle and really elevate the voices of the communities that they serve, right? And that's part of what we see as under attack here. Certainly one of the side effects, if you will, of assaults on the Voting Rights Act, as well as other things. Um, you know, as both Sejal and Abba noted, the Voting Rights Act, obviously it has profound implications on individual voters, and that's where it really becomes a voting rights issue, because certain voters, individual voters, their votes are diluted, et cetera, and it is a very legitimate and important voting rights issue. But I think we would argue that it also impacts the voice of nonprofits indirectly by impacting the voices of the communities that we serve, that these issues are intertwined. And so what I hope to do is just, de-silo this a little bit and think about the implications on our nonprofits. Right now, there's about 450,000 nonprofits across the country doing advocacy and or lobbying work. That's based on independent sectors, 31% data finding, and extrapolate that out to the whole population of nonprofits. And these nonprofits are working on everything from housing to food security, education, tax and budget matters, gun violence. And, as someone who used to do a lot of that advocacy work, I've sat in rooms with state legislators and given them all the data points, and they look at me square and say, yeah, I hear you, but I'm still not going to do it because the communities you're talking about don't vote, right? And so these issues are intertwined. And so the communities that are most dependent on nonprofit services are often the same communities that are most vulnerable from losing representation with a weakened VRA. And as a result, as the voice of those communities is diminished, so is the civic health of the nonprofits that serve them. If the communities served by nonprofits have their voice diminished, diluted, or silenced in any way by erosion of the VRA, then the political clouts of nonprofits to advocate for funding for core programs is diminished at the same time. And and this, as a result, has a direct impact on a lot of issues that we always talk about. And as I think Sejal or Abba, I forget which one, noted, this is not just about the congressional races, but it also impacts all levels of government. So, the city council, where housing groups might be advocating for more affordable housing. If you're dealing with, if they're allowed to have more at-large districts, less representation from the lower income communities or struggling communities in their cities, then they're going to have a harder time advocating for those housing policies, right? The state legislatures, where nonprofits may be working in coalition to expand funding for education and youth services, it becomes more of an uphill battle. And of course, we have the Congress, which is what's at stake here with Callais, specifically at least. But the ruling will have implications on all levels. But the specific case is congressional, which obviously has impact on everything that we've talked about, from the healthcare acts, healthcare funding, and a number of other issues. And in addition to the advocacy work that nonprofits do, nonprofits are also very engaged in the voter engagement space, right? About 200,000 nonprofits or more actively do some form of voter engagement with the communities that they serve, whether that's GOTV, voter registration. And while Calais doesn't directly impact the ability of a nonprofit to do voter registration, it means they're doing that work in a more stacked or skewed system. And we always hear about apathy, voters who throw up their hands and say there's no point in voting because the system is rigged. Well, if you have a serious vote dilution, and if you have things like this, then there's some legitimacy to that, and it becomes harder for us to push back against that sense of apathy and alienation that people have. And so I think this is important as a voting rights issue, but it's also important for us as nonprofits, as we seek to advance the missions of our respective nonprofits, as we seek to advance the interest of the communities that we serve. And the last thing I'd say is really that this is a continuation of mean, we've seen a lot of things happening to the nonprofit sector in recent times over the last year or so. We've seen cuts to funding from the grant rescissions and large scale cuts that have resulted in staff rollbacks at nonprofits, ending of whole programs. We've seen the administration go after the C3 status and a whole host of other things we've seen that nonprofits have. The VRA, again, depending on how the Supreme Court rules, Callais case could significantly diminish the voice of the communities nonprofits serve and the voice of those nonprofits at the same time. We haven't talked about Turtle Mountain, but depending on how the Turtle Mountain case is settled, that will directly strip nonprofits, particularly a lot of the nonprofits we work with, like Brennan, League of Women Voters, NAACP, that are often the litigants in these cases. It would strip them of the right to file claims under the VRA. And so that it would have even more, in some ways, even more direct and profound impact. But that's a little further down the pipeline than Callais. But yeah, again, really appreciate all the work that Sajal and Abba brought to the table as far as the legal side of this. Just want to make sure when nonprofits look at this, we're looking at this as this is deeply intertwined with our missions as nonprofits and the ability of our nonprofits to serve the communities that we work with.
Thank you so much, Brian, for drawing those connections, especially around advocacy, which is, my wheelhouse, and tying that to, concerns of legislators for, populations that they perceive as apathetic and not engaged in voting. So lots of connections there between programmatic work, advocating for, policies that help communities that nonprofits serve. So I hope people remain, closely attentive to what's happening to this case. I'm going to transition us a bit more. And Brian, you partially answered this. You already answered the second question that I had for you about nonprofits engaged in voter engagement, how that would for voter engagement, candidate education, GOTV, how that would impact them. So I'm going to move us along to talk about what's next. I know we've given an overview of the case, an overview of Section 2 in general, how this ties back to nonprofits and why nonprofits should care. So let's talk about what comes next. What are some of the approaches that are being considered to reform partisan and racial gerrymandering? I think, Abba, you may have touched on this earlier, you or Sajal, but I'm going to call on Sajal for this one.
Sure. I'm happy to get started on this conversation. I will just say one added context that we haven't quite talked about yet is that the Supreme Court has basically said partisan gerrymandering cannot be litigated through the federal courts. And so that is another part of the background of this. And so a lot of the work in addressing this is being done at the state levels. There are several states that do have restrictions either in their constitutions or other statutes on partisan gerrymandering. And so using sort of state-based litigation or state law-based litigation is one of the big things. It's something that we do a lot of here at the Campaign Legal Center. And our redistricting team has just gone through some saga in Utah, but it's on top. So there's continuing work there. But there's a couple different sort of policy proposals that are typically considered here. The first is independent redistricting commissions. And so what that does, and this is typically done at the state level, though Congress can pass a federal law that requires independent redistricting commissions for congressional redistricting as well. And it basically would take the politics out of the redistricting. It's done differently in each state, but it would create a group that is separate and apart from the politicians to create the districts. And the hope is that that takes away the incentives that sort of affect the politicizing of redistricting. Right, because, and again, another like sort of background principle is like we redistrict because the population changes over the course of the decades. And so the idea is to make sure that we have effective representation, we redistrict every 10 years. Now it seems like more than that, but it's supposed to be 10 years. And so that is, so the independent redistricting commissions are one aspect of it. And they would also be responsible for making sure that the maps that they draw meet the requirements of the VRA. And so that they don't dilute the vote of minority populations. Other policy changes are that several states, and some of those include California, Oregon, Virginia, Connecticut, Washington, Minnesota, and Colorado, have all enacted their own voting rights acts. And those voting rights acts, they do a couple things. They sort of update the standards for kind of the current moment. So the VRA, the Federal Voting Rights Act, was passed in 1965 in that particular moment. And while the language was updated in 1982, it's mostly stayed the same. And so these statutes sort of create a newer standard that's more applicable to our current political climate, but also current sort of social and racial divisions as well. And those often mean that the standards are easier to meet right now. And so there are more successful claims under some of those state VRAs. Now, again, not every state has them, but I think, places like CLC and our partners work with state legislatures and with folks on the ground to pass good state VRAs that will protect the populations of those states. Additionally, I mean, general, just, again, we can talk about how realistic federal legislation is, but, any other sort of invigoration of the Voting Rights Act, the John Lewis Act is one example of something that's been kicking around Congress for a while that would reinvigorate the Voting Rights Act. It actually would bring back some form of pre-clearance. And those are ideas that I think would be very helpful to, looking beyond just the VRA as it's currently written to add more tools to addressing both political and racial gerrymandering.
And I'll pause, Alba. I thought you were going to respond to that. But I want to ask too, I know that Alba, earlier you had talked a little bit about some of the states that we can look to, the Alabamas, from the past, to kind of get a sense of how things will go. Are there state cases that we should be watching right now that could, sort of shape the next phase of voting rights litigation?
Yeah, I think Sejal actually touched upon a lot of the states that we should be
Mhm.
looking at who have included their own Voting Rights Act, and who have concluded in states like Florida and others that have actually included their own redistricting restrictions on legislatures to not allow them to do partisan gerrymandering, for instance. And another thing to remember about state laws that I think we often forget is that, like, so some states have put in a thing called a Voting Rights Act. Some states have put in a thing that says, here's what you can and cannot do when it comes to redistricting. But the vast majority of states, even those who don't have those specific provisions, often have far more robust protections of the right to vote than we find under the federal constitution. And that is something that we need to remember as a real powerful tool for voters and for organizations and for anyone who's trying to influence their lawmakers. Say, we have the tools in states like Wisconsin and Washington and New York to be able to provide robust protections for voters. Those can be seen as, in the federalist ideal of like these little laboratories of voting rights developments. And I do also want to say, this is, for the people on this call, this is the kind of bread and butter of our work. We work in voting rights, we work in this kind of litigation, and it can be very easy to feel despondent at times like this. I think, Brian mentioned that feels like an assault on the Voting Rights Act, and certainly I feel it, I get it. But I do want to just clarify, like, this is not the first time that there has been what feels like an assault on the Voting Rights Act since 1965, and the case law as it's developed is not universally only gone one way. It's gone this way and that way as courts and legislatures have tried to calibrate to figure out what is the right answer. Just a few years ago, we talked about the Alabama Voting Rights Act case just a few years ago, and we were litigating that. Everyone said, like, oh no, that means the Voting Rights Act is dead on arrival. Supreme Court is going to, take a hatchet to it, and it didn't. The Supreme Court said, no, we're not going to change what has been the standard and what is still working under these principles. We don't know what's going to happen at the end of Callais. But even if it's not something that the voting rights community or the voting rights advocates would hope to happen, that does not leave us without levers, both in state courts, Congress. We should never write off Congress, which has a lot of power, even if it's not at this moment willing or able to use that power to really put some guardrails in place that apply nationwide. The Supreme Court is, of course, the court where the buck stops. where all these kind of redistricting cases of whether they're going to be allowed to go forward ends. But we've seen outside of the Voting Rights Act context and outside of the redistricting space, we've seen lower courts across the country, really stand up for the law, for the rule of law, and really stand up for the principles upon which this democracy was founded. And that has a lot of salience. Not every case goes to the Supreme Court for a final resolution. And unless and until the Supreme Court totally undoes the law as it exists, we need to make sure that we're using all the tools we have in our tool belt to make sure we're protecting all these. And I just, I teach a class, and I always want to inspire people to say, like, this sometimes can feel very hopeless, but there's actually a lot of power for people who feel strongly about the cause and for good advocacy. Really does have the power to move the needle. We've seen it throughout history, and I'm confident we'll see it again.
No, and thank you, Abba. I'm glad you mentioned that you are a teacher, because I felt like this was very much a call to action and sort of a inspirational sort of push. And thank you both for just the great breakdown and the explanations. I do want to remind people to leave your questions in the chat. I'm going to get to those in just a moment, but I want to pull Brian back into the conversation. I have a final question for all of us, for all of our panelists here. I know we've heard a lot about what's happening, and I want to make sure people have the resources that they need to continue to get information, accurate information on this topic. So Brian, what resources would you recommend, for people who want that clear and accurate information around these issues? I know that you all at Nonprofit Vote do a great job of putting out some resources, so I'll kick it to you first.
Sure. Well, when it comes to the VRA and the court cases around the VRA, we usually follow, again, groups like Brennan and some of these groups that are deeply involved in the litigation, Campaign Legal Center, et cetera, with, Sagel's group and some of these organizations. Most of what we're doing is we're basically taking that information and relaying it to the nonprofits that we work with. Because again, the nonprofits that we work with are very concerned about this. And I think, as we mentioned earlier, what is it that we can do about it? Because obviously it's in the court's hands. There's not a whole lot a nonprofit can do at that point, at least at this point when because it's being litigated, the court's going to make a decision. Now, I think Abba alluded to this a second ago, or, I've been on enough of these calls to know that at least if you're reading the tea leaves, the assumption is that they're not going to completely gut it, but they might weaken it. How much they weaken it, we don't know. And that's what we're going to find out when the Supreme Court ruling comes out. But beyond that, yeah, are there state VRAs that folks can get involved with? Down the road, could we work with the Congress to get a John Lewis Act passed? There are things that we can do. And so I guess my call to nonprofits is to remain civically engaged. Start looking at what resources you have as an organization to protect your nonprofit's voice and the communities you serve, to ensure that their voice isn't diminished, and see that as part of your mission and the work that you do.
Sejal, anything to add in terms of resources?
I would say, generally speaking, staying sort of up to date on what is going on in these is useful, just because the sort of access to political participation is the core of our democracy. And a lot of what we do at Campaign Legal Center is about transparency. And so, just a plug for us, we put out lots of different news alerts and things like that. That could be really helpful. But then I also think, to a point Brian made, like, especially at the state and local levels, plugging into different advocacy networks and that are working to create more equal access, whether that be through new legislation, whether that be through some form of other activism. I mean, those are the ways that we build ground. To Abba's point from before, which I think is an incredibly important one, these things fluctuate, they go back and forth, but we don't just watch them go back and forth. We have to push it forward. And so we take the steps that each of us can take in our everyday lives to do that. And it can be as simple as making sure you stay up to date, or going to a meeting, or doing something like that.
Thank you, Sejal. I want to make sure we have time for questions here. So I'm going to invite my colleague, Esther Jory, who is Policy Counsel for Independent Sector, to come on and do our Q&A. So Esther, I'll turn it over to you.
Thanks, Vanna, and thanks to all the speakers. This has been a really wonderful and informative panel. So we have got a number of questions, and I'm going to we'll see how many of them we get through. One topic that came up more than once is if you could talk a little bit about the SAVE Act and whether or how that might interact with the Voting Rights Act. That's a piece of legislation, if you don't know, that was recently passed by the House that would impose a number of changes nationally on the voting process. I think probably the thing that people are most familiar with is that it would impose ID requirements at the time of registering to vote. And I don't know who wants to take that one, but
So I'm happy. Sorry, go ahead, Brian.
I'll defer to Abba or Sanjay as far as any implications it has on the VRA, because I don't know what I'm not sure if it intersects with, it might intersect with the former clause, the vote denial claim, perhaps. But I don't know if it touches the redistricting at all. But what I do know is from a nonprofit perspective, and we've been organizing around that because, it's not just about voter ID. And the one thing that I think is important is, even a real ID, which you'll see people talk about, is not proof of citizenship. This is really a passport or a birth certificate. And importantly for nonprofits and the many nonprofits that we work with that are out there registering voters and doing GOTV work, it would literally strip nonprofits of the right to register the communities they serve, period. Because the only people who are authorized to review that documentary proof of citizenship are election officials. So you could talk to people about registering to vote, but you would then have to tell them to go in person to an elections office and bring a passport or birth certificate in order to register to vote. There is a clause in the SAVE Act where they say they still preserve the federal mail-in ballot, mail-in registration form, but it's weird. They say, yes, you can mail in the federal registration form, but before it becomes active, you have to physically bring your proof of citizenship to an elections office for it to take effect. And so, in addition to all the things that you've heard about the SAVE Act, it would effectively eliminate the ability of nonprofits to register voters in their communities or their clients. And obviously, the new version has a few variations, but I don't know if there's a legal implication as far as the VRA goes. And that I defer to Abba and team.
Yeah, I'll just say I agree. I don't think it has much to do with the kind of Callais case that we're waiting on right now or the redistricting space, other than the kind of broader theme of we're seeing an effort out there to make it harder for certain kinds of voters to vote. And eliminating rights under the Voting Rights Act is one way to do that. Imposing new barriers and burdens that are going to be harder for some communities than others is another way to do that. It's all part of a general kind of theme that we're seeing when it comes to the need to really stand up for some of our most vital and fundamental democratic institutions. I'll just say as a kind of aside, like the problem that we have in this country is not that people are voting out of turn or voting falsely or voting twice. It is that people are not voting enough. So when you think about like what is it that we can do in these times, I also just want to go back to, first principles of don't forget door knocking. Don't forget engaging people, all the more so if we're seeing some of these laws come down from the courts or Congress that feel very disheartening. It's very easy for people who already feel marginalized or like it doesn't matter, like their vote doesn't matter. It's very easy for like that to sit it out. And it becomes only more important at that point that we engage them.
Thank you. So another question we got about the VRA is there an opportunity, is there a mechanism for a plaintiff to file a private cause of action to enforce the VRA if that person felt that their vote had been diluted because they had been districted into a gerrymandered district?
So yes, right now. So the thing about the Voting Rights Act, and this is just to get like a little bit of a technical legal aspect of it, there have been hundreds of cases under the Voting Rights Act brought by private parties. And that has been true since its passage in 1965. There is some statistic on which I think like 80% of the cases have been brought by private parties versus only 20% by the DOJ. And so it has always been presumed that the Voting Rights Act has a private right of action. There is a challenge to that, and that's what Brian referenced in the Turtle Mountain case. And the Eighth Circuit found that there was no private right of action under the Voting Rights Act. As of right now, that decision is stayed by the Supreme Court. And what will happen next is still up for, I think we'll see. But historically, I think there's very firm ground that private litigants have been the backbone of bringing their rights to fruition in this. And as a former lawyer for the DOJ, like, it was obviously something that was absolutely necessary. There have never been enough attorneys working at DOJ to litigate all of these cases across the country. It has always been about communities standing up for the rights that they deserve.
Thank you. So one final question. Relatively late breaking news. There's been reporting around a potential executive order or a draft executive order wherein the president would be reported might declare a state of emergency to try to increase presidential power over elections. So I don't know if anyone's actually seen it. I don't even know if the language is out. But in general, could you talk a little bit briefly about the exercise of power over the administration of elections, and when traditionally the executive branch, the federal executive branch, has been able to exert that power, and what might happen in order to expand that?
I'm happy to start this off. So the Constitution gives the general regulation of elections to the states, with Congress as being the sort of federal force that has the power to, affect those rules. So it's the states and Congress. That's typically what we see. Now, Congress does delegate some power to various federal agencies. The president himself has no authority to regulate elections. And that has been, there's litigation over his first executive order about elections, many provisions of which have already been enjoined by a federal district court in DC. My colleagues are litigating that case, and it continues to move, but so I don't know what is in this executive order. We shall see, and we shall all work together to figure out what to do next. I do want to just say one note, which is that I think that the sort of threat of these executive orders kind of coming like pretty constantly puts a lot of fear, rightfully so, in people's minds and whatnot. But our most effective tool is using our voice and using our vote. And so these things, while destabilizing, should not be deterrent of acting and using your political power. And I think that's the thing that, if there's like one point to make about this, I think for me, that's it.
And if I can just jump in just to echo Sejal here, because I think that's the message we try to drive home with Nonprofit Vote and the work that we're doing when we do, because we've been doing a lot of legal workshops for our partners on like how to, understanding some of this legislation. It's because it's that onslaught. It's the everyday. It's intended to overwhelm and make people feel like powerless and lost. And so I think it's imperative for nonprofits to remain civically engaged and not, retreat amid, the various onslaught of executive orders, many of which will be struck down. Hope not all, but many of which will hopefully be in the end struck down.
If I can just add so I think probably could be a whole other session that involves 20,000 more people about executive power and executive orders and the SAVE Act and all these things that I know are really kind of hot button issues. And certainly it's not been news today, yesterday, this last week, or anything that this administration wants to exert more executive control over elections, which have traditionally been run through the states and constitutionally run through the states. There is legal action against executive orders. There is legal action against this push to nationalize elections. Those are cases that are winning. Like I said, these are the courts are standing up for what has long been the case. But it really also puts into, I think, really important contrast a statute like the Voting Rights Act. the Voting Rights Act, which was developed through Congress in obviously enacted by Congress in 1965, but then reauthorized by Congress several times after. It has been largely part of bipartisan agreement when it comes to enacting that statute, and it has been a conversation really between the Supreme Court and Congress over the last 50, 60 years about the development of that doctrine and that case law. That is how this law was built. It is so deeply rooted and entrenched in our history, in our democracy, and in our kind of three branches of government, in a way that these new and one-off and obviously very vulnerable attempts to exert kind of one branch over another are just different. And it just shows all the more so that, Voting Rights Act was not a fly-by-night idea. It was not like a passing thought. It was not something that had some salience at some point, but not anymore. It is something that Congress, the legislative branch, the executive branch, and the judicial branch have long understood to be something that's really necessary to guard against our worst evils when it comes to protecting our democracy. So it really brings into relief just how important it is historically and how much importance it remains. Particularly when there are other assaults on the right to vote, we need to make sure we are holding firm to some of our most fundamental principles.
Awesome. Thank you, Abba. And thanks to all of our wonderful panelists. This has been an extremely informative, just educational session that I personally enjoyed myself. I've certainly learned a lot. And Brian, I know you mentioned, as well as Sejal, the importance of just civic engagement for nonprofits. And I just want to plug our initiative that we've got coming up, Voices in Action, starting over the summer, which will provide some tools and resources for nonprofits to step into civic engagement. With that, I want to thank our panelists this afternoon for this incredible session. In a second, I'm going to turn it over to my colleague, Ben Kershaw, to go over some policy developments. But thanks so much to our panelists for joining us. Feel free to hop off for the next several minutes while we go over these policy updates. But again, we appreciate you joining us. And with that, Ben, I'll turn it over to you to talk through what's happening on Capitol Hill right now.
Thank you, Vanna. I'll try to be really quick. I know people's brains are full of really good information that I don't want to dislodge. I think the one thing to keep in mind about what's going on Capitol Hill and in DC right now touches on this question we heard about the SAVE Act and this rumored executive order. So let me just address that kind of first. Right, you heard the substantive updates. I'm here to give you idle speculation. What is different now compared to yesterday, before these media reports had broken out, is that we've received pretty clear signals from the Senate Majority Leader that they are not going to change the rules of the United States Senate to pass the SAVE Act right now. That's what has changed in the last 24 hours, and that is why you're seeing the activists who have been pushing both legislative and presidential action, releasing their plans to the press. They would have loved Donald Trump to have issued this executive order weeks or months ago. And so now they're going to pressure him publicly to do that. But again, we've talked to people who are close to the White House since this reporting came out, and they don't have any firm information, but they say to take it seriously. And we've seen that things can go from rumor to reality, or at least to executive order, rather quickly in this administration, this version of this administration. So stay tuned. The other thing that I guess I would note in the last minute I have with you is that you ought to read the DC download that my colleague Travis Swanson writes every single month. But if you're only going to read 1 month, this is a great one to start. We have updates in there around a recent concerning hearing in the Ways and Means Committee around some related lawsuits that the independent sector has filed recently. Some good, rich, detailed content for you for when your brain maybe has a little bit more space in it. So I'll drop that link in the chat, and grateful for the time, Ben.
Great. Thank you, Ben. Short and sweet. And in addition to dropping the DC download in the chat, it'll be available in our follow-up materials. So with that, thanks again, everyone, for joining us. I hope you enjoyed today's session. Please fill out our survey to let us know what you thought about our webinar. And thanks, Ben, again, for those updates. We really appreciate it. Thank you, Brian, for joining us. And you all have a good rest of your day.